Election Petitions Tribunal, comprising of selected justices of the Supreme Court of Nigeria, will in the next few days begin to consider cases lodged before it in the aftermath of the exercise, which was held on the 25th of February of this year. Now, it took the whole of 6 days before the Independent National Electoral Commission announced a winner of that contest. It might take longer for the courts, but judiciary authorities are already warning against that, given the state of the nation. Senior lawyers Olisa Agbakoba and Femi Falamna, both of them senior advocates of Nigeria, well, they've called for petitions to be decided before inaugurations are held. There have also been calls for a live telecast of the Presidential Election Petition Tribunals and the sittings, and we have Michael Anduaka, the senior advocate of Nigeria, former Attorney General of the Federation and Minister of Justice, joining us now on the program. Great to have you with us. Thank you for joining us on Newsday.
Thank you very much.
Well, we have spent a chunk of the program discussing judicial reforms before you joined. There's a current discourse on the severe need for these judicial reforms. How could that help in these processes that we are about to encounter?
Well, generally, judicial reforms have been a continuous process. And mind you, any alteration of the Constitution amounts to a kind of judicial reforms. The judges themselves generally interpret what the legislature has enacted. By January, everybody's expectation is for quick dispensation of justice. And I think the reforms have to do more with procedural rules. For instance, in matters of election petition or pre-election petition, it would be desirable to do away with preliminary objections being taken separately and the judgments being taken separately. We would appreciate that reforms should go deep in solving that problem where people went to court, presented petitions, preliminary objections were filed to the petitions. They took time to hear the matters on merit. Just for judges, some rulings came that the matters were struck out just on the issue of the preliminary objection, and no judgment was given on merit. The overall effect of this was that most of the plaintiffs who went to the higher court could not get remedy because 180 days had expired. Most of the cases dragged at the lower court, pre-election petition dragged at the lower court to the full 180 days. It was naturally expected that judgment would be given on merit, even if the trial court opposed the preliminary objection. But in most cases, after taking full 180 days, the judge will come with one page, I agree with the preliminary objection, and I've struck out the matter. When the person goes on appeal, the Court of Appeal, in their wisdom and correctly too, say if I repeat the case, the 180 days constitutional provision have expired. So there has been very great injustice, and these reforms, there's need for us to look at that aspect. And also, in my opinion, like other countries, I have been wondering why the governorship election tribunal goes to 3 stages. When I was Attorney General, such a proposal came, but I turned it down because I saw the presidential election tribunal starting from Court of Appeal and ending in the Supreme Court. All other elections started from a tribunal and end at the Court of Appeal. So I did not see any justification why the governorship election will go to 3 stages: Tribunal, Court of Appeal, and Supreme Court. So that is another area we have to make some reforms. There should not be such a disparity. If at all there's going to be a disparity, it should have been the presidential election, and amendment may be effected so that the Supreme Court hears once and for all as a court of first instance.
All right, very good.
So that is some of the comments I've made.
Very good, Mr. Ndoka. Now, let's talk about 2 issues here. The televising of presidential tribunal deliberations and ensuring all litigations are closed before swearing in. Is it possible to achieve this, you think?
First, the issue of televising is desirable, but proceedings of the courts are open and everybody has access to it. The issue is now, do the Supreme Court or the tribunals, like the Presidential Tribunal, do they have the resources and the equipments to start televising now? But the constitutional provision is met. Trial should be an open court. Parties should have access to it. And that is exactly what the Presidential Tribunal is doing. Coming to the issue of whether the trial should finish before swearing is highly desirable. But it does not violate the Constitution if it does not finish. Because the Constitution says the trial should take 180 days. And I don't see any problem in that. The reason is that if the court of first instance, in case of presidential, which is the Court of Appeal, gives judgment, even if the election is nullified, and the president-elect appeals to the Supreme Court, he will remain as president. And the presidential, the Supreme Court gives a decision. So we must allow the judges to operate within the ambit of the Constitution. The constitutional provision has been that do everything at the court of first instance within 180 days. Of course, issues are commenced by written summons. Testimonies have to be given. The judges have to evaluate. The judges are doing handwriting. So we must appreciate the special circumstances the judges found themselves. It's not just one presidential petition. I think there's a couple up to 3-4 presidential petitions. And then to say that do them before the swearing in, I don't find it conceivable. And when I was Attorney General, there was a presidential election petition that dragged on until 1 year before judgment was given. And that is the wisdom National Assembly tried to abridge time and say, look, do presidential election tribunal, which is supposed to be 180 days, do the appeal 60 days. It has already shortened the 1 year or the 2 years the election petitions used to drag on. So I think we must use wisdom. All the people that wish that the election should finish before the swearing is desirable. And that is why I say there's one area we must look at. Most countries, they take presidential election straight at one shot at the Supreme Court because the whole country is waiting. So maybe because of the desire by this of the public to have this hate tempestuously, we should look at, in the course of our judicial review, look at whether we can separate the presidential election, amend the Constitution, and make the filing of presidential election petition be at the Supreme Court as court of first instance and final. Just you can see beside, it's done in Kenya, and most other countries, dispute relating to elections, presidential election, are filed directly at the Supreme Court. At least that is one window we can look at. And I have said it is obviously desirable to have the election tribunal finish before the swearing, but it may not be practically possible because the judges are human beings. The volumes of authorities have been cited. And of course, some authorities may even be overruled, or the Supreme Court may have reasons to depart from their previous decisions based on the authorities. Years have passed, things that have changed, the nature of amendment that occurred in the Constitution. Some of the authorities may not be applicable. Also, you look at the Electoral Act, some of the authorities that were delivered may not be applicable now. But one key thing that strengthened, I think the judges should be allowed to look at whether they can strengthen the process of election. Because emphasis have always been on the result of the election. Not knowing that a corrupt process also can produce a system that cannot stand. And I think this is a window that everybody should be pushing to allow the judges start from the process in looking at the grounds that deals with corrupt practices and non-compliance. Let the judges look at the process and see whether they can lay a solid foundation for this country. That if the process is strengthened, then the result that comes from a very sound foundation will be credible. I think that's what we should have consigned everybody. Because if we don't say, rush, do the election, look at the results, and decide, I don't think we are missing the point. And that is the point we have always been missing. Because the law should be looked from the foundation, which envisages that elections should be free and fair as stipulated in the Constitution. The judges should look, because we have done it over and over in the country. And time has come to allow the Supreme Court or the judges in their wisdom look at the whole process